Welcome back to the Layman's Law School podcast, where we break down some of the latest cases that are happening in the news that everybody's talking about. One that's been very popular is, of course, the Karen Reid trial that's going on right now, which is what we're going to cover today. There's so much going on. We had to really put our heads together and decide, what parts we wanted to break down for you guys, because we know most of our audience is paying attention to that trial and has a lot of feedback and a lot of comments and opinions about it. So
strong opinions.
Right. Very much so.
Well, we'll start us off, Lens. Look, I even got some red, white, and blue stars on it for
patriotic
Officer O'Keefe, because that's what this case is truly about.
That's right.
Absolutely.
It's in blue line.
I got the upside down beer.
Yeah, I'm not perfect, Shawn.
Yeah,
You're going to have to figure it out.
Well, he's over there shaking it up. He's trying
No,
to.
you just did it.
But does that really work?
This is another
Spin it.
trick.
Is that you just round it?
You spin it and then it'll take out all of the.
Well, happy Friday. It's still
Mine turned out perfect. You didn't do 3 full circles.
Oh.
happy Friday, gentlemen and lady.
That's right. Cheers, cheers,
Ooh,
cheers.
Another good week.
Bit. Yep.
They've been riding
Don't let me
the truck
hang
a
on
little
to
while.
Yeah, there you go.
Busy week, but a good week.
Fantastic as always.
One and done.
One and done. One and done. Don't worry, Trace. I'll take yours. It's fine. Don't worry about it.
Back
Yeah.
up
Take
here.
for this one.
Synchronized city or something.
Yeah,
Something
so-
crazy.
So, there are a lot of podcasts that cover this thing minute by minute, second by second, witness by witness. We want to kind of just do an overview of what we've seen so far. We're into like day 13, I think, of the trial going forward. So, kind of wanted to start from the beginning and go through just the changes that we've seen so far in
And day 13 of the second trial.
of season 2 of Karen Reid. Yeah, so in season 2 of Karen Reid, we saw a number of changes. One, first of all, Hank Brennan has been brought in as special prosecutor to replace Adam Lally. And right off the bat, we saw the defense come out with an actual theme and to tell a story prior to the trial where we see Adam Lally.
To tell a story.
God, I did it again. Yeah, the prosecution.
They'll get you in the comments if we don't.
Yeah. The prosecution come out with an actual story instead of what we saw from Adam Lally was a blue collar, I guess, job where he went out there and he just recited the facts for 30 minutes.
It was terrible.
Yeah, well,
In my opinion.
I wasn't going to say that, but we got a story
better.
From Hank Brennan. At least, and we had what we call a theme, and we'd use those in trial all the time. And this was the data, the facts, the science, or what's going to actually prove the case here. That's going to be the black box from the car. It's going to be the forensics data from her blood test. It's going to be the videos. It's going to be the science from the phones that are going to prove what occurred here. And for all intents
and on Officer O'Keefe himself, the science on the body and the state it was in and all that obviously has some conflicting things with the weather, but it certainly comes into play.
Yeah, it's kind of a sidebar, but I think most of our viewers probably know or have heard me say this before and like I'm the marketing director for the law firm that you run. And so it's interesting to me that when we talk about like the prosecutor telling a story, like that's very similar to what marketing does, right? Because you're trying to market your client.
Persuade people.
And persuade people. And so for me, I can tie things together a lot quicker when we talk about that because most people, juries or audiences, won't like that's big now and that how you are supposed to do your marketing and tell stories. And so in other words, it's the prosecution, again, I think the defense is doing a great job, but their opening statement from the prosecution, he did exactly what he should have done to tell that story, and he did a good job of it. And I can recognize that as a marketer, not just as a lawyer, but as a marketer.
No, that's good. That's a good point. But they had something in this particular case that they didn't have in the first case, and that was clips from actual documentaries that Karen Reid or interviews that she had done, and they were able to play those during the opening and throughout the trial, throughout different witnesses. So if I could, I just want to bring up clip number 1, let y'all see that and react, because I think this was in the opening of the prosecution's case.
I mean, I didn't think I hit him, but could I have clipped him? Could I tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see. Or could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Okay. Just talk about when he was when she saw him in the snow. Although that's not clear. I was going to point out, like, even in that documentary, that clip, it doesn't point out when she says he didn't look mortally wounded. When you go back, when you hit him?
Exactly.
Mortally wounded when you hit him? Like, that's what I interpreted from that clip alone. If that's the only part of the clip they showed, then 100% you're like, well, wait a minute. When did she see him and think he wasn't mortally wounded? So if you're the jury, like, you're not getting the whole story if they're just playing these clips from picking and choosing.
That's right.
What clips?
But they're allowed to do that. They're allowed to do that. But at the same time, these are statements.
Even if they're out of context.
That's right. And it's the defense's job to actually come back and fix all that stuff. So,
one of the problems with that is it's just like when you talk to the news, and we talk to the news, and my dad being a politician that trained me well is when we can talk today and on podcasts and be long-winded and blah blah blah. It's fine, but if you're being interviewed for the news, you need to keep things short, 5-6 sentence or word sentences, because once they cut it up, they can put it in any order, any way you want. And so if you're doing a documentary, the documentary crew their job is to make it entertaining. And so you may not get to tell your whole side. And then if that's used in court, it's not a great thing. Right. And so, we've talked about a little in the past on the podcast before, is just shut up. Don't do these things.
Well, and the thing is, I don't know if that clip came from I'm watching a documentary now. There's multiple episodes called A Body in the Snow or something that's about this, and it appears that she did this documentary on her own. Like,
she's even dumber.
She was the one. It wasn't like CBS or ABC came to her and said, "Can we interview you?"
Yeah.
It looked like she actually produced this documentary, contacted people so that she could produce it, and at the beginning of it, they were said, why do you want to talk now? And, it was about, well, I want to be able to tell my story, type thing.
She want to be able to pay her legal fees.
Well, and
that's what they say. The reason she did
it's probably true. I mean,
that she was running out of
money.
money.
Doesn't have an option.
And it's a good way because, as a criminal defendant, she doesn't have an obligation to testify. And the judge will instruct the jurors that, in no way, shape, or form can they hold that against her or infer anything about her guilt. But this is a good way, essentially to tamper with the jury pool by getting some documentary out like this, by having the statements and her side of the story out, which many people probably have seen. And then even if the defense plays these clips in any way, shape, or form, out of context, to try and make her look bad, then, there's a rule that allows you to play the remainder of it as the defense. So if it's that important and it made it look that out of context.
But Shawn, it's the same thing as when, it's a little bit of a stretch, but bear with me. When you have opposing counsel say something or do something that's inappropriate and you have to make a quick decision, but a lot of times those decisions are, should I object? And you say no, because it's not hurting you or whatever. Or if I object, it's a big one that it's going to really impact the jury because now they take it serious. Now they know.
So, that's important information.
Yeah. You brought attention to it.
And now every single time that you're combating what your client has already said, they've already heard it in that framework. And so now, like, even if you take 90% of it off, there's still 10% that's sitting there with them.
Right.
It's just a bad idea.
Yeah.
Sure.
Right. Yeah. And like what we're talking about is the Fifth Amendment right to not incriminate yourself. You have the right to plead the Fifth. Made famous by Dave Chappelle. I plead the Fifth. Well, 1, 2, 3, 4, Fifth.
F-I-F. That's awesome sketch.
Yeah.
Well, and it's in a criminal case, it's not even pleading the Fifth. It's just you have a right to testify or not testify.
Yeah.
The prosecution can't call you as a witness as a criminal defendant and make you plead the Fifth in front of a jury. You just can either elect to testify in your own trial or you can elect not to. And 99% of the time, criminal defense attorneys are going to tell you that it's not a good idea for you to testify. It's always your choice, but they're going to give you advice that you shouldn't testify.
So you would say, no, Karen Reid, you are not testifying if you were representing her.
Probably in this case, yes. There's only a very, very, very limited amount of cases I think that would be, almost required to build your defense.
Sometimes you have no choice.
Sometimes there's only one other person there.
Yeah.
And if the client doesn't testify, their side of the story never gets out because there isn't 6, 20, 50 witnesses or whatever to cross-examine and cast reasonable doubt. Sometimes the only way you can get your defense out is by the client testifying.
Yeah, that makes sense.
I mean, one thing I'm gonna kick it to you, Chace, is that, and I've never been in that situation, so I try to put myself in there thinking that way, but I've never been charged with a crime that I didn't commit and don't believe I committed. But if I did, then
guilty every time.
Yeah, I've been guilty every time. But if I did, then I would want to scream it from the rooftops, and I understand that as a human thing. It's like our clients that they want to scream it and say, "Look, I didn't do this." But that's not a wise decision.
Not always. Yeah. So sometimes we've had criminal defendants that we know that the case is really close and that it may hinge on what they have to say, and they are passionate about the way that they feel about the case. They really want to testify, and I'm
telling you, I'm going not testify. I'm going doing like a documentary or an interview with the news
I would never,
stuff like that. That's what I mean.
Yeah, I never advise them to do any of this. So I'm very surprised with the experienced defense attorneys like Alan Jackson, that this would been something that he would have allowed. I don't know. You really can't control Karen Reid, but at the same time, she's helping prove their case.
Yeah. I'm putting it this way. Can you think of a situation where that like a documentary or an interview would actually help you as a defense attorney?
No,
I can't either.
No,
I can't either.
No, all it's going to do is all it's going to do is open up cans of worms everywhere. And I'll show you what I mean by that. So let's go ahead and go, I think, to clip number 5.
When you walked out of the bar, how many drinks had you had?
I had probably about 4. And not 4 that I completed either. I didn't drink maybe more than a few sips at the waterfall.
And 4 drinks you felt fine to drive?
Yep.
And is the level of intoxication pretty high here for everybody?
It's happy.
Yeah.
It's
because you'd had a lot to drink, right?
I wouldn't say I'd have like a normal amount. Like a vodka tonic every 40 minutes.
Okay. And so are you feeling like buzzed? And I'm not judging, I'm just trying to get a sense.
Buzzed. The final count somewhere. The final count of my alcohol intakes, probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like all soda water with lime. Not that I needed to be a martini, but it might have had a splash of vodka in it. So I said, John, this drink tastes like it has no vodka in it. And he said, just get a shot and mix it yourself. So each drink was being counted as a double. So I would get a vodka tonic and then I would pour a shot into it. So that counts too. Frankly, it just felt like a regular cocktail. It was just a really weak pour, so I asked for a shot. So for my taste, it just tasted like that's the normal strength of what a drink should be. So I had maybe 2 or 3 that are being counted as 4 and 6, and I don't know. I felt fine. I felt like I was buzzed. And then there was one drink, the last one that was given to me, which I would have counted as 3, but they're counting as my 6th cocktail. The guys that we were with brought around the shots, and they gave me one that I didn't drink, but I poured it in my drink. So that's now my 5th and 6th drinks, with the 7th, which is a shot that all the men did, and I poured it. So that one glass that I'm holding, that I go into the waterfall with, has 3 drinks in it, a vodka tonic and 2 shots. And which is why John said to me, you're not leaving that drink here, like you haven't touched it and just poured a bunch of onions, like just take it with you, which was something he always did. So then I go into Waterfall and I put that drink down and I socialize most of the time. So that would have been my 5th, 6th, and 7th drinks. Then John orders me a drink at the Waterfall that I don't drink, that he takes with him. And then there was a round of shots that Chris Aller bought that I did take. So that would have been the night. But I did not consume 9 vodka martinis or take 9 shots, depending on how you count it. And the last 2 drinks, I did a touch.
Well, I can tell you right now, I was annoyed just to have to listen to that long diatribe of her going over how many drinks she had and if they were weak or whatever. And I think she's innocent. So for me to watch that and be like, God, okay, shut up, Karen.
Mm-hmm.
Like,
right, yeah.
I mean, that, and I hate, like, they were trying to compare, but then it's almost like they were like, let's do the last one is just this long, over and over, like, what is she, can she get to the point?
Well, and there's some, in the documentary I'm watching, which has many, one-on-one interviews with her, some of the stuff is kind of contrary. Yeah. She totally makes excuses for, I know I didn't say that, but I remember saying something to this effect. I had a lot to drink. Yeah. I had, it's just weird that she's trying to minimize the amount of drinking that she was doing, but then saying that she was buzzed and
she isn't. Yeah.
I think there's, I know Chace is going to clean it up for us, but there's a lot of problems. Number one, you're losing credibility. You see it because you're saying, well, that's what I think I had to drink there. And you're talking about you may have drank somewhere else, and you're going through all these different things. And what you have to remember, and this is why we kind of talked about it before, is to not give any of these interviews outside of court and your lawyer and all that stuff. It's because it is not illegal to have a drink and drive. But there are people on the jury who believes if you have 1 drink, you should not drive. And that's not the law, but that's what they believe.
Yeah.
And so when you're sitting there and you're going, like you're saying, you may not believe that, but a jury member may. Yep. And she's spending 5 minutes talking about how many drinks and doing shots and mixing shots and changing this and changing that and ordering this. I guarantee you there's somebody on the jury, if she'd have just said, I had some drinks and kept it like that, they would have been more receptive to that than, well, I think I had this shot and I poured it into this cup, and then, well, so-and-so always takes his drink, so I just jumped on that. That just makes it 10 times worse.
Well, it basically,
like it was a weak drink,
basically sounded to me like I had anywhere between 4 and 44 drinks. Yeah. I don't really know.
Right. None of that was good. Nope. And
that whole thing was hard to watch.
So there's a couple of things to focus on here. First of all, this elements of the crimes that she's been charged with: manslaughter while operating a vehicle under the influence of alcohol. That one of the elements is that she was under the influence of alcohol. Now she's talking about 9 separate shots, possibly, of drinks that she took over the course of 4 or 5 hours.
And sounds like some good evidence of being under the influence.
And then admitting to being buzzed. All that type of stuff.
That's it. I mean, that reaches the element there.
Right, right. Then we got the second-degree murder charge, and that is just the unlawful killing of a human being with malice aforethought. And I'll get to that in a second. Some of the evidence that the defense was able to show from some of her statements that we actually did see in the first trial, and then leaving the scene of collision causing personal injury or death. So
we're going to talk about the elements of different parts of the accusations. But that's a big thing. Is if you don't have A, then you don't have to worry about B and C.
Yeah, that's right.
And so in this specific instance, she's just giving them,
giving them,
yeah, right.
Especially for that manslaughter while under the operating a vehicle under the influence of alcohol. So I honestly think that if they're going to convict her of anything, that it's going to be that one.
Yeah,
it's to split the baby a little bit.
Exactly, and I think that what's going to bury her here are these statements that she's making, and I'll give you an example. She called him over 52 times between midnight and 6 in the morning.
That seems normal.
Right? She texted him on this day over 200 times.
That's love.
John, I'm here with your fucking kids. Nobody knows where the fuck you are, you fucking pervert.
Nobody knows where you are, you effing pervert. This sounds like a drunk woman, out of control.
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. She's sleeping next to me. You're a fucking loser. Fuck yourself.
But he goes through 52 phone calls that aren't answered.
And I've listened to most of those voicemails, and I think in my mind they're helpful to her. Why they may, people may not like her. People may think exactly what you is. This is a crazy drunk psycho bitch.
Yeah, but
why is she calling him all this time of night if she thinks he's dead? If she ran into him with a car, things like that. So I mean, I think they're helpful. I mean, I don't think they cast any doubt on her credibility just because of the way that she is. People may not like her, but I think they're helpful to go to show that she had no reason to believe that he was not okay.
Because she was still calling him.
Well, I think her story is that, she saw him go in the house and that she was worried, are we welcome? It doesn't look, the lights are, not a lot of lights on in the house type thing.
Yeah.
You go in and check, and that he went in the house and didn't come back out. And then after she sat there for, 5 to 10 minutes, her estimate, she finally got pissed off because he just went into the party without her and didn't even come back out to say, yeah, come on. So that's why she left. So, I see where they definitely make people think, wow, this lady's crazy. But I don't see how they show any type of motive that, like, it's supposedly after she would have struck him with the vehicle. What motive they show that, she was so pissed off at him that she ran him over, or,
I agree. But the other side of that, if I'm looking at it, trying to be unbiased, I agree with what you're saying. The other side of that is, well, maybe she was so intoxicated she didn't know what she did. And that's what they're that's what the prosecution got to go with there. That she's so drunk, she hit this person, didn't even know she hit him, which hurt some of the other elements. But she's so drunk, she's admitting to having all these drinks. She's a lady who's not a big lady. She's having 9-10 liquor drinks. Yeah, she doesn't even know she hit him. That's the inference that I'm getting.
Could I have hit him? Right. That's the statement that she keeps saying.
That's what they're building it on, is that she did these things without even realizing it, but she did them.
Yeah.
So it cuts both ways a little bit, and it's really going to be like we were talking about with the drinking is, what is that individual juror going to think about that? What is that individual? Everybody's different. So
and I think that the prosecution has scored a lot of points with, and I have a number of more they've played a lot more clips from these documentaries. Not going to play them all.
It's a long trial. We can't get to everything. We just
right. But they played clips of her admitting that basically saying that Peg, John's mother, thought that she hit him with a car, thought she did something wrong. That's supposed to be some sort of like consciousness of guilt evidence. And the defense has scored some points there, but the defense has come out with a very good strategy. And one of the things they recognized was that one of the elements are things that have to be proved in order for you to convict somebody on that particular crime. So for manslaughter while operating a vehicle under the influence of alcohol, there has to be a death resulting from an unintentional operation of a vehicle while under the influence of alcohol. There's another one that is leaving the scene of collision caused by a personal injury that causes personal injury or death.
Can I have time out on a layman's question?
Yeah.
Okay. If she is saying, hey, I had these drinks and I was feeling a little buzzed, but there's no evidence like a breathalyzer or whatever to prove her blood alcohol level, then how do you,
Shawnee. You take
her blood and you analyze her blood, which they did.
Okay.
But even if you didn't have that,
what did she come back?
How?
Well, That's just it. They did a very strange test that they don't normally do for proving DUI cases. They did it at the hospital, and it includes alcohol that your body naturally produces with food. It produces alcohol.
It's higher than normal.
It's higher than normal. She refused to give a urine sample for some period of time. First of all, she was almost admitted into a mental hospital because of the way she was acting after this. And
suicidal.
So they were considering. So this is the type of thought process she was in, or whatever. She was also on her cycle. She basically felt like it was an invasion of privacy. She felt weird about doing it, so she didn't give the urine sample right away. But then she eventually gave the blood sample, and they are trying to extrapolate backwards. So from what she was that morning, going back in time, considering how many drinks she has, and they're trying to get there that way.
Okay.
Stuff. But there's other ways, sometimes it's how you're seen driving, but it kind of cuts both ways. And what Chace you're kind of talking about is that you can't prove one, how can you prove the other? And both of them are interplaying, meaning did the impact occur? And if the impact occurred, then that leads you to saying, well, she must have been DUI because that's a harmful event.
Gotcha.
But if you can't show the impact occurred, then you can't show that she was DUI. It all comes back to that.
Okay. Yeah, and that has been what the defense has done here in the second case. The first case, the story was that the theme was, and it was the first things out of David Unetti's mouth. Karen Reid was framed. Okay, that this was an investigation that, rushed to judgment, that tried to take any sort of focus off of the homeowners and the Boston police. And in the second one, what they're saying is, and what they're arguing is that, and he said it multiple times throughout the opening, he repeated it 3 times. He said there's no collision, there was no collision, there was no collision. This is based on the ARCCA experts that are going to come and testify that, in their opinion, that he did not die from a car strike, that he did not die from being hit by a car. And the fact that the medical examiner, Boston's own Canton's own medical examiner, couldn't determine how he was killed or whether he was killed by a car. So this was a homicide or not. And so in each one of the elements for every single charge, there is a requirement that there is a collision with a vehicle. And so if they can undermine the idea of, and the state's case, that there was a collision here, then she goes free on every single one, because there's something called disjunctive and conjunctive types of elements. And conjunctive means that it has to go together. Disjunctive means you can have one or the other. So if it was disjunctive, you could prove that there was a death resulting from an unintentional operation of a vehicle and get a conviction without having while under the influence of alcohol. But if it's conjunctive, that means you have to have a death by vehicle and under the influence of that. You have to have both, right? And so all of the defense has to do is take away one of those elements, and the whole thing is off.
Okay.
And so that's what they're focusing on.
The element that is not strong is not under the influence of alcohol.
Yeah.
That is not strong.
Right.
You can't attack that.
Right.
She's already killed it in the documentary.
Yeah. I think so too.
So you got to go a different angle there.
Right. And so they're attacking the collision, and the collision is their strongest thing, just because we've seen the video, we've seen the pictures of the arm. The arm is the biggest issue, I think, for the prosecution.
My question is, so ARCCA is accident reconstruction, right? Mm-hmm. So why would their testimony, why would a jury believe them over like first responders or police? What's so strong about having them?
How about this? I'll start it, Chace.
Versus...
So because that's an independent agency that's looking at purely facts, and where your first responders are there to try to help and resolve the situation. So it's more of the first responders are there not to investigate as much as they are to try to fix as much as they can with the problem. Yep. And then they're not, when they're investigating, they're not going back in time. And so a reconstructionist is trying to go back in time and saying this is how it was even prior to the impact, or if there was an impact, and all that stuff. And they're not perfect. And you're going to have this guy say it happened this way and this guy say it happened that way. And a lot of that's going to be, what the jury believes, who they believe, if they believe this expert over the other one. But generally, it's going to be that kind of situation where you're going to have both sides are going to have an expert that says what they want.
Yeah. Honestly, I want you to think about it this way. Say you're buying a house, big decision. You're pretty scary about it. Yeah. It's pretty scared to invest a whole lot of money into a home. And you have somebody that's a paramedic that tells you, hey, that's a really nice house. And it's, I've driven by it plenty of times and it looks really nice. I've been in there and it's a beautiful home.
Or even you go with your dad and you bring your dad there and your dad looks around and says,
yeah,
great. Everything looks great.
Right.
Yeah. And then he starts banging on the walls.
Right.
Yeah, it's good walls here.
Right. And then you have the option of hiring a home inspector.
Yeah. Okay.
Right. And so when you want to talk about the credibility and the reliability of the evidence and the reliability of the testimony, ARCCA is going to win out on those particular things. And of course, the state's going to have their own expert, and hopefully it'll be someone that does a little bit better job than the one in the first trial. The one in the first trial was, he had a rough day at the office. Yeah, it's the best way to
say the least.
To say the least.
Well, like I said,
but I want to make it clear. I mean, a lot of the first responder, that's really not their job.
No,
So they're not. That's
they're there to save lives. Yeah.
Right. So I mean, it's not. We don't expect them to.
But that's a great point that you bring up, because 2 of the first responders have been brought in as witnesses to testify to her saying, "I hit him. I hit him. I hit him."
Sure, and that's excited
2 people who
utterances
should not have been worried about what Karen Reid was saying,
right. Which wasn't on video.
Mm-hmm. Yeah.
Right. And so I guess I asked that question because to me, like, yes, I think having ARCCA be part of this was very important, particularly when we're talking about the possible incidents and alleged corruption that's happening. Yeah, I wouldn't trust a single one of the people police officers, unfortunately, that are up there because the waters have been very muddy from all of this. So, I mean, I think it was great that they had them come in. Like you said, they're an outside party that doesn't have a dog in the fight, so to speak, when it comes to like they don't work for the police department or
who paid for the ARCCA.
Well, here's the thing: is the ARCCA was originally was brought in by the federal
FBI,
law, originally, and then the defense, once they came back with a favorable opinion, the defense started to foot the bill for their travel for them to come testify. And then that makes them then a defense witness. Mm-hmm. And so,
which is
that's weird,
harped on in every case, whether it's our personal injury cases, whether it's criminal cases where we need an expert. People don't do stuff for free. I wouldn't, I've had cases that involve.
That doesn't mean I'm going to lie.
Exactly.
It just means I have to get paid for what my job is.
I've had cases that involve, the death of children where a family member or mother or father, is alleged to have shaken this baby to death. And, we've hired, the foremost expert, medical examiner who deals with these cases all the time out of Miami, Florida. And if we had to have that individual come to Augusta, Georgia to testify,
got to pay him, Shawn.
They just don't get on a flight and come up here and say, "Hey, yes, they're not. They're not in. There's no public defender, medical examiners, physicians that just say, "Yep, for justice, I'll come up there and give up my practice for 2 or 3 days." It doesn't happen. And even for them to look at the case in advance,
you got to pay them.
Yeah,
they gotta have some.
There's some things that I'm going to do for free, but I'm going to take 12 hours, to do something that's my job, and just say, okay, I'll just do it for free,
right?
Because you would be, if you were the foremost expert on it, you would be inundated with nothing but people asking for free services, and you just don't have the time to do that.
Yeah, and so. It's going to be a battle of the experts when it comes down to how this, how he actually was put in that state out on the front lawn. The state's going to have their experts. Defense is going to have theirs. Honestly, I feel like the defense is got a little bit of an edge.
I do too. One of the problems I see for the state, and we've talked about in the first trial, is that when you don't do an investigation correctly, you lose, so much credibility. And that goes with experts. If there is the state's expert saying A and the defense is saying Z, And then the answer is, why aren't y'all in agreement? It's because the investigation wasn't done properly. I mean, that's tough for the prosecution because you're bringing the case. I think that's very important to remind everybody.
Right.
This isn't a innocent or guilty. This is a not guilty or guilty. And you said it earlier about, I think she's innocent. I don't know if she's innocent. I believe she's not guilty. There's a whole different argument there.
Absolutely.
Yeah. One of the things that I think we need to focus on is like we've seen there's been a lot of testimony overall, but there's a gut feeling that we get about these cases, and there's a gut sort of leaning that you get when you're watching something like this. And so far, I'm seeing in the first trial, I was far, far to the defense side. My gut was telling me, okay, that this is not going the prosecution's way, and it didn't. But when I see all of this, and this is building, he hasn't just played those 2 clips or the few clips that I played. He's played 10, 15 clips of this. A lot of stuff that she's played. And everything from what she's actually saying to how she's actually saying it, is building towards a conviction in my mind, for the manslaughter with a vehicle while under the influence, and at the very least that she was DUI while she was, doing all this stuff. But I think that the defense has got to really score some points, and we haven't seen it yet with Proctor. They haven't come out with the Proctors.
That's fish in a barrel there, my friend.
Yeah, they've got.
So how could you not score points?
I can go in there right now and get some points.
I mean, if the prosecution calls him.
That hasn't been called yet.
I mean, I don't remember what evidence would be absolutely crucial that Michael Proctor would have to be a witness for in order to get it into evidence.
Well, he's got to have a lot of chain
his
of
partner,
evidence.
what was Budnick?
Yeah, Buchanan.
What he couldn't testify to, because he was there for most of the type thing. But if there was a way that the prosecution cannot call him,
they're gonna try.
I would not call him, but the defense obviously can call him as a witness anyway. So he may be a defense witness because they've already gone over, a bunch of the Michael Proctor stuff with Buchanan, if I pronounce that correctly, the text messages and all that. So they've really already gotten it out there. So they may not call him at all if the prosecution doesn't call him.
Yeah. So how would that work if you're I mean, this is somebody that's trying to prove your client is guilty, right? But I mean, why and how would you call them in your case in chief as a defendant?
That would be the strategic, decision you make. What could you get out of him?
Talk about why you can.
Yeah.
You have a right to call any witness that you want.
Yeah.
If as long as you get them under subpoena and they have, relevant information to the case. But you would have to make a strategic decision of, as a defense attorney, does this witness possess information that I need to get out and get in front of the jury that no one else has? And then what else could he provide that could be harmful to me? And do I want to go over these, text messages and everything and show that he was, aiming for Karen Reid? Do I need to do that, or have I already done that enough with the other witness that admitted to all of it? There's just a balancing act that you have to do in order to determine, what is, if you bring him up as your witness, well, then obviously the prosecution gets to cross-examine him and ask him everything helpful to their case.
And they get to lead him.
I think that's very important. I'm glad you brought that's. I don't think people understand how different that is to have somebody on cross versus direct, and how much you can travel your own path when you have them on direct versus
right. So, like for example,
that's what I was getting to them. Yeah,
for the audience,
for
the layman.
That's why I said
explain the difference between.
Okay, I'll do a direct. I'll do
I said cross-examining when it wasn't.
Right.
Yeah, I'll do a direct for Reid. I'll just say, Reid, what time?
God, I'm scared.
When did you get up this morning?
Unfortunately, I was up about 5 because my son has poison ivy and was kicking me in my chest.
Okay, and when did you head to work?
Contractors there about 9:30 today.
You're not under.
Okay, and
I'm not gonna lie.
No.
I texted y'all.
Okay.
I was like, I'm stuck
And where did you meet the contractor?
at the house, at my house.
All right. And how long did that take?
I'm not sure because I left as soon as I could get them to move their vehicles out of the driveway.
Okay, so every question I just asked was about like who, what, when, where, why.
Yeah.
Right. How,
Sure.
that type of thing.
Yeah.
But this is
Cross.
a cross. I would say you woke up at 5:30.
I mean, I don't know. Maybe I did. It was later. I don't know.
Okay.
I don't know.
So you woke up at 5:30. Okay, and then you met with a contractor later that day. Isn't that right?
Yeah, I mean, it was the morning, but yeah, it was later.
Okay, and you met with them at your house, correct?
Yeah, it was at my driveway, but yeah.
So if you have a witness that's kind of like flimsy, okay, then your strategy is to just
I would continue.
You're just basically telling the story.
And one thing that is key,
because if they're not telling you, no, that's not. What
I'm suggesting the answer in the question.
Yeah, okay.
You woke up at 5:30.
Right.
I'm not even asking. You woke up at 5:30? Question mark. But really, it's a statement.
One of Vic's.
I'm testifying.
Yeah.
One of Vic's greatest things
agreeing
he
with
always
me.
does is, and he gets objected to all the time.
Mhm.
But all he does is just say statements and then go right. That's it. And then then he doesn't even listen to if you say right or not. He just keeps going.
Who's the founder of the law firm.
Yeah.
So, but you're just telling your side of the story, basically. You're basically,
narrating, testifying.
Yeah, and
you're so much more in control.
Yeah.
When you're on cross-examination than you are on direct examination, unless you've really prepped your witness on direct examination.
Even if you have, Shawn.
Even if you have,
we have this. I was about to say,
but
I had a deposition the other day, and I prepped like you wouldn't believe. And the first question is XYZ, and she goes ABC, and I go,
and some of the things that when you want to make a point in cross-examination, a lot of times it doesn't even matter whether they say yes or no.
That's
because you can ask them.
You know what the answer is.
Several questions in a row, and even if they're the next question you're gonna ask, you can just turn to the jury and ask that question and say, if Reid was on the stand, I can turn to the jury and say, Mr. Sanders, isn't it true that you have absolutely no idea when you left the house?
Objection, but they've already heard it. Doesn't matter.
No,
doesn't matter. I know.
And he's really already that. If that's what I was really trying to persuade the jury of, that he has no idea what time it was. Even if he says, he's already said that he doesn't know. It's whenever the contractor's left.
Well, even if he answers the question, then
but even if he says, even if he says, it was probably around 12, to come here type. It doesn't matter.
Doesn't matter
because I've already, given them
pointed out.
You've already heard it once. You've already kind of heard it again. And then I asked the ultimate question that is, I'm telling you exactly what has happened.
Yeah. And you can phrase it in a way that, I guess this is my point on this, is like Shawn's saying, you can have it. You don't say something that is going to be objected to unless you have it set up. So you set it up and then you ask that question.
Oh, yeah.
And the opposing counsel is absolutely going to object, but it doesn't matter. The jury's already heard it and they can piece it together by the prior testimony. So that is such a huge advantage when you have somebody on cross.
I mean, there's things that I've seen. You could say, so you're saying that's what happened, Mr. Sanders.
That's correct.
But you didn't write it down in your report.
I did not.
You didn't document it anywhere. You didn't notify dispatch that you did that particular thing.
I didn't.
You didn't tell any of your other officers.
No.
You didn't tell your supervisor.
Nope.
You really didn't give a shit, did you?
I mean,
that's going to get objected to. The judge is going to admonish me for unprofessionalism. But I've already told the jury that this guy doesn't give a shit about this investigation.
And they have pieces to put that together. You set it up. I didn't do this. I didn't do this. I didn't do this. So that must mean I don't give a shit.
Right. Yeah. But he suggested the answer in the actual question.
That's exactly.
And that is the
But if you do that on
If you do that on direct, you'll get objected to right away.
Yeah,
There's been some of that going on with Hank Brennan. They've let him get away with it some because he is usually a defense attorney. And so he's used to crossing. And so he has been leading, like in Jim McCabe's the direct, he was leading quite a bit, and he got away with it for a little while, and then eventually got admonished for it. But
that's another good thing.
It's a hard habit to get out of.
Layman law school is that for the defense on that situation, You may have a legitimate objection for the first thing and the second thing, but we've talked about a lot. It is strategy of when you say it, because if you say it, then it means this must be important. And if
what are they trying to hide?
Exactly. So if the guy's saying stuff that's not hurting you, even though it's objectionable, you go, I ain't really worried about it. You know, you just let it ride.
Yeah. Having said all that, there have been some wins for the Commonwealth. There have been some real wins for the defense as well, and their cross-examination of some of the experts. We're going to have to let this whole thing play out, but at the same time, I'm at this stage leading a little bit more towards a conviction of something.
I think the defense has got some haymakers that is coming. I really do.
Okay.
I think they've set up some things, and I'm curious if they're going to do, but one of them's the temperature and the body of Officer O'Keefe and that situation.
We're gonna talk about that.
Okay. Well, I just know that's going to come into play. And anytime, if you have good lawyers, if you watch half of a trial, you will believe that side, no matter what.
All right.
I mean, that's good lawyering. So I'm with you. I think the state did a lot, or the Commonwealth, excuse me. I don't want to get slammed in the comments.
Yeah.
But we're just used to saying the state. They did a good job, much better job this time. But I think that they got some serious issues that are about to come up.
Yeah. I agree. Well, I think that'll do it for this time. Thank y'all very much for watching. And if you enjoyed it, like and subscribe, and tune in next time.